Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, Law Street Media, and Fastcase. I'm your host, Tom Hagee. Today we're going to talk about pixel litigation. Probably a little more than just pixel litigation, but pixel litigation. Yeah, I didn't know what it was either until I did, and now so can you. I have to wonder if there's anybody left in the world who just doesn't assume that they're being tracked. And you think about how much good all that could do if we were able to use all this data for good, and in some cases we are. But sadly, there's greed and evil in the world, and so there's a lot of harm that can be done to individuals or groups, even nations. Yeah, certainly there's a humorous side to it. I put up on Facebook a picture of what I thought were some really funny pajamas. Turns out the image I grabbed were children's pajamas. So now the internet thinks I'm a 7-year-old boy and need some new jammies. That's amusing. But on the other hand, of course, and this is obvious, but I'm going to say it anyway, when certain private information is used or gets into the wrong hands, like your health information, your financial information, your health status, some serious harm can be done to you. There's been a lot of activity in the pixel litigation arena having to do with video privacy and all of our conduct on the web, how we engage with websites and how we engage with video. Some big organizations have been implicated, like the National Football League, National Public Radio, some big hospital chains. Dozens of class actions are filed against Meta, Facebook over their pixel tracking tool. And to get an understanding of all this, I get to speak with Myriah Jaworski, who's a member at Clark Hill PLC. We explored the privacy issues and cases on the rise and how these can impact businesses and consumers. We had a wide-ranging discussion, really. We talked about everything from cookies to session replays. We talked about how current laws are being used and, how they're being adapted and where they came from in the first place. About the implications, the potential implications, in light of the Dobbs Supreme Court decision overturning Roe versus Wade. And there was a recent case involving protections for gun purchasers in Pennsylvania. People who would rather, buy a gun and not have everybody know it. People who might get pregnant, might not want everybody to know it or anyone to know it. We also talked about the Video Privacy Protection Act, federal act, which was enacted in 1988. That was deep into the last century. To make you realize how long ago that was, I looked it up. The top song of the year was Faith by George Michael. I looked it up. I clicked on the video, so that's now in my profile. I don't want it to be there. I'm not going to say it's a bad song. It's poppy and all that. It's not my taste. But, I was a little embarrassed watching it for some reason. I don't know why. And so now the internet thinks I'm a 7-year-old boy who likes to dance to George Michael in his pajamas. But back to Myriah. She represents clients in defense of data breach class actions, privacy torts, and statutory claims, pixel tracking and commercial surveillance matters. She works on internet defamation cases, technology disputes, cyber subrogation claims. She defends clients in response to regulatory inquiries and investigations rising out of data incidents and privacy practices, including before state attorneys general offices, the Federal Trade Commission, and Department of Health and Human Services, the Office of Civil Rights. She's a certified information privacy professional in the U.S. and international. She's got all those credentials. She was also a trial attorney with the U.S. Department of Justice. She has a joint JD MS degree from Syracuse University School of Law, where she graduated magna cum laude, and a BA from George Washington University, where she also graduated with honors. So here is my interview with Myriah Jaworski from Clark Hill. I hope you enjoy it. Myriah Jaworski, thank you very much for doing this today.
Thanks for having me, Tom.
Okay, so first, let's talk about you. How did you? What is it you do at your firm, and how did you land in this field? Is this something that you, as a little girl, dreamed of doing, or
Didn't we all have these dreams, Tom?
I think yes, we did.
So I'm currently a member in the data privacy and cybersecurity practice at Clark Hill. Clark Hill is a international law firm with 27 offices throughout the United States, Ireland, Mexico, et cetera. And I lead up the cyber privacy and technology litigation initiative, where I work with businesses, really the defense of businesses in consumer class actions that have to do with data privacy, data breach defense, wrongful collection, et cetera. So I actually started my career at the United States Department of Justice through the honors program in Washington, D.C. So I've been a litigator my whole life. However, when I was coming up, data privacy wasn't really a practice group yet. So I was more involved in sort of crisis response. And then around 2015, crisis response became really incident response, data breach defense, et cetera. So I came up with the space and with the industry.
Okay, cool. Well, you getting to pixel tracking. What is pixel tracking? I mean, we know what pixels are generally. It's what all digital images are made up of, right? Everybody knows if you blow it up, you see all these little dots. So
Sure.
what are we tracking?
So pixel tracking is really one of several different types of tools or code really that work to evaluate user behavior in an online and digital world. So cookies are probably what most listeners may be familiar with, right? We have first-party cookies. Those are essential to the website's operation and functioning, and those are cookies that the website operator will drop on a user browser. Then we have third-party cookies, and those are really more advertising-oriented. They're non-essential. They're used largely for contextual, behavioral, various advertising purposes. Cookies are essentially embedded code and embedded on the browser. And so there's ways that users can control the cookies, right? There's ways that we as website users can evaluate what cookies are dropped on our browser. We can delete the cache of cookies, et cetera. That's a little bit different than pixels. So pixels are another type of tracking tool, but they're a bit more pernicious than cookies for a few reasons. To your point, they're really just HTML code or graphics. But what they do is they transmit information, directly from a website or directly from in an email and like an email newsletter back to the web server. So there's this whole aspect of user control and functionality that exists in the cookie landscape that doesn't really exist in the pixel landscape. There's not as much that users can do to disable pixels. It's not as easy, right? So there are extensions, there's scripts you can run, et cetera, but it's not as easy as getting a global privacy control or sort of clearing your cache. The other thing about pixels that I think differentiates them from cookies and makes them really effective in the ad tech ecosystem is that pixels can be used to track users across devices, right? Jumping from computer to mobile app, from websites, et cetera. There's other tracking tools, right? Session replay, for example, which we'll talk about later, I'm sure. But really the advertising pixels they're just very effective in the ad tech environment. They allow you to report back on user behavior, everything from how a user is engaging with the website, right? Event sessions, we call them, how they engage with an ad. Overall, they're the fundamental building blocks of sort of understanding your return on investment, you as a business, when it comes to advertising, when it comes to some of your marketing initiatives. It allows you to target not just different demographics or audiences, but it allows you to target at the individual level.
Okay.
So that's fundamentally sort of the role of the pixel in this larger online tracking technology or commercial surveillance world.
Okay. Is it that granular that it knows where on the screen you're clicking or paying attention? Is it that granular?
Between pixels and session replay technology, I mean, to see session replay in action is really kind of incredible. It is what it sounds like. It records and allows you to play back a user engagement with your website or with your app. So yes, it does everything from, this user hovered over this ad for X amount of time. It is at that level. But I think there's probably an important piece here that is important to the litigation. It's also just important to understand. By and large, the information that's being shared and collected is not actually what we really think of when we think of personally identifiable information, like historically, right? It's not Myriah Jaworski is hovering over this ad, or Myriah Jaworski is engaging and made this purchase necessarily. I mean, it can be if it's associated with a profile or a subscriber ID, et cetera. But in general, it's more like advertiser ID or user ID is engaging with this URL that has this title. that may be associated with this general geolocation. So I just want to be clear there, because it's important when we start talking about the class action lawsuits and the case law, that the data elements that are being collected, there's a big question around whether they constitute PII, whether and how they would constitute PII.
I gotcha. Okay. Well, we'll get into that a bit more. So there's a trend of video privacy class actions. Meta or Facebook has been a favorite target, and there are dozens of class actions claiming that their pixel tracking tools being used to send personal video consumption data from online platforms, from the online platform without consent. I guess that's the general idea. And they're brought under the Video Privacy Protection Act of 1988. So let's start with the act itself. 1988. That's before. Wasn't, I mean, that was before Facebook and before big social media, right?
Sure was. But another sort of initial point to make before we jump into the VPPA,
Sure.
The meta pixel litigation, like the consolidated class action up in the Northern District of California, et cetera, doesn't actually have a VPPA claim to it. So we're seeing a lot of different claims addressing the metapixel. VPPA is one form of lawsuit, but in general, these lawsuits, are traditional privacy torts, include breach of contract claims, include sort of state privacy law claims, et cetera. Okay. The VPPA is a specific subset of this larger metapixel litigation that's specific to the use of the metapixel to relay information about user viewing activities, right? So yes, to your point, Tom, this is an old statute. The history is fascinating. It was enacted by Congress following the failed nomination of Robert Bork to the Supreme Court. As many people by now are familiar with, apparently during his nomination, Bork's video rental history, I think from like Blockbuster, was leaked to the press. I don't know if it's necessarily that there was something scandalous about what he was watching. I think it was kind of unremarkable, but it was just the idea that a reporter was able to obtain a list of the videos that he had rented, and then distributed it or published it, essentially. Gotcha. That offended a large contingent clearly of Congress and led to the enactment of the VPPA. So what does the VPPA do? It has like 4 essential elements, but it essentially prohibits an entity that constitutes a videotape service provider, right? So that's the first element. Are you a videotape service provider? Are you acting as a videotape service provider? From knowingly disclosing personally identifiable information without informed written consent. And what plaintiffs are able to do is they're able to leverage the VPPA because it has a private right of action, right? So when we talk about sort of the plaintiff's bar, we think about class actions. There really needs to be, if we're going to see lawsuits brought under statutes, those statutes really need to have private rights of action, and they have to have associated statutory damages. So the VPPA happens to have both those things. And what the plaintiff's bar is doing here is they're essentially saying, you website operator, you constitute a videotape service provider because on your website, you allow for various video technology. You're showing pre-recorded videos, right? And there's already been a defense of live videos. They're not in statute or in scope. It's really got to be pre-recorded video materials. Okay. And you're allowing, through the use of the metapixel but through other cookies and other tracking technologies, you're sharing that information. This user ID clicked on this URL that was associated with this video, right? That's the allegation. You disclosed it to a third party, and you didn't have my informed written consent to do so. So that's been the sort of fundamental elements of a VPPA claim as we see these claims brought against major publishers, news media organizations, marketing organizations, consumer brands, et cetera.
Now, how has it evolved, I guess, since 1988, before my children were born? How has it evolved and been broadened over the years?
There's been 2 main waves. So there was an earlier wave with the onset of like the Netflix and around the 2011 era. And then we saw the VPPA filings kind of die down. And now in the last year, we've seen a major uptick in VPPA class actions and other sort of wrongful collection privacy class actions pertaining to, again, the idea that you're using these tracking technologies, you're using Metapixel to disclose certain information that is protected by law. Here, the information that's protected by law is video viewing behavior.
Okay.
So this is, I would say, probably a second wave of VPPA litigation, but certainly a much bigger wave.
Right. So here's kind of a general question, which I'll just throw it out there. I mean, where do basic privacy laws fall short? And why do you suppose it is we don't have real federal privacy law? Why don't we just start with the first one?
Yeah, sure. Let's talk. So I think what I would say there is, so there's two things, right? We have these historic privacy laws that were designed for one context that are now being leveraged for this online ecosystem. So it's not that they fall short per se, it's that the VPPA in California is the California Information Privacy Act. Like, these are historical state and federal laws. The Federal Wiretapping Act, for example, they were devised to deal with ad technologies, online ad technologies. So do they fall short? I would argue that they're really just being applied in new contexts, and it's not a perfect fit. Secondarily, when we look at, we do have these state privacy laws out in California. We have the CPRA. Now we've got Virginia, Connecticut, Utah, Indiana, Iowa, et cetera. So we've got about 6 to 7 state privacy laws, comprehensive privacy laws. We take in the States in general a much different approach to consumer consent than they do in the UK. So in the UK and in the EEA, European Union, with the GDPR, there's the idea that businesses are really prohibited from processing personal information unless they have some lawful or legitimate basis to do so. And consent might be one of those bases, but you're prohibited unless you have consent. Whereas in the States, the approach that we take is, we can collect information, we can process and even share information. We just need to make sure businesses are disclosing that they're doing so, right? So that's, you need to update your privacy policy, your terms of use. And in some laws and in some states, we need to provide users with the ability to opt out of that data collection and opt out of those data sharing and data sales. Okay. So we don't have our hands around this idea of consent. And I think what that leads to is instances like, certainly with the Metapixel, certainly with the Metapixel in the healthcare context, where information is being collected online, and maybe that information, that data collection practice was in fact disclosed in a privacy policy. Oftentimes it was not, because the businesses, but candidly, weren't even fully aware that those pixel tracking activities were occurring. But the idea is, we put it in our privacy policy, it's there. Your use of our website, your use of our client center, your use of our patient portal was pursuant to the privacy policy, and that should be sufficient. And courts are grappling with, I think certainly Congress is grappling with, legislatures in different states is grappling with, like, is that sufficient for consent purposes? What kind of consent regime do we really need in the United States to effectively address some of these consumer privacy issues?
Okay. Well, two things come to mind. First, I like how you described, when I asked you about, do the laws fall short? And you're saying the laws are being adapted to whatever circumstances or things that come up. And that's kind of the whole purpose of this podcast. But as I think about it, I don't know international law. I'm still trying to learn American law, but it seems like that's what we do anyway. I mean, just with the Constitution itself.
Absolutely. So. It's iterative, it's living, and a lot of emerging litigation, Tom. A lot of advancement is really just leveraging the tools that we have that exist currently and trying to apply them to new situations. And we do that because, for a variety of different reasons, congressional movement, even though there is general bipartisan support in this space in Congress, we're still, without a comprehensive federal data privacy law and other initiatives. Yeah.
The other thing that comes to mind is, I'm wondering, because we have to have consent. It's the cynical person in me, I suppose. Does anybody believe that they're not being tracked? Don't we all kind of expect that no matter what we do, somebody knows it somewhere? I mean, that's just my cynical view. I don't know if that's cynical or realistic.
I think that as a consumer, of like a consumer good or service, yes, there's an awareness now, consumer expectation and awareness around online tracking, I think does accord with what your impression is, Tom. The difference is when I'm online, yeah, sometimes I'm a consumer and I'm trying to shop at J. Crew and buy a shirt, and I don't mind. I'm seeing advertisements for discounts on similar shirts. But when I'm going to my patient portal at a hospital or a medical facility, and I'm logging into my patient portal and I'm scheduling appointments or, reviewing various doctors, I don't have that same expectation. Right. I think the expectation of online tracking being prevalent, it exists in that consumer realm, but it doesn't exist with respect to sensitive personal information, with respect to information that's regulated by other regimes, financial information, right? If I'm going to apply for a loan, I now generally apply for loans online, right? I used to go into my bank. There used to be a lot of paperwork involved. That process is really largely online and automated. And those protections that existed in the physical realm, I think there's questions as to whether they exist online as well.
Okay. All right. Speaking of new uses for old laws, so a number of these cases, one of the issues raised was how plaintiff attorneys are being very creative about applying traditional causes of action to litigate modern privacy issues. I don't know if that's a controversial statement. I don't think it is. What ways are plaintiff attorneys, do you see, are they getting creative in applying these causes of action?
Absolutely, they are. And to their credit, right? It's not a bad thing to utilize the tools that are available to you. I think a really great example and recent example of true plaintiff bar creativity is a recent federal filing in Pennsylvania, the Irvin versus Cabela litigation, just filed last month. And what they did there is they sort of unearthed this existing statute, the Pennsylvania Uniform Firearms Act. And apparently this Firearms Act protects information pertaining to gun purchases and says, if I am a consumer and I'm making a gun purchase, that information has to be confidential and not subject to public disclosure. Of course, that Uniform Firearms Act has a private right of action. It has those statutory damages provisions that we talked about. So what are they doing? They're saying Cabela's, which is this large online retailer, utilize the metapixel. And that the use of the metapixel, actually worked to disclose information regarding gun purchases to third parties in violation of the act. So I think absolutely the plaintiff's bar is creative. I don't think that's an insult. I don't think it's a controversial statement. I think they are creatively looking at existing laws throughout the states, right? We litigate in both state and federal courts. They're doing their research. They're unearthing and discovering these old statutes, and they're applying them in new online contexts. So I think the Cabela case is a unique and new example of metapixel leading to liability under a sort of historic state law. Okay.
Well, the physical stores are amazing things to walk through if you do anything outdoors, but the gun section, it's quite an arsenal whenever I've stopped in one. But I could
Did you even know that in Pennsylvania, if you're a Pennsylvania gun owner, apparently there's rules and restrictions regarding the safeguarding of that purchased history information and requiring that it be kept confidential. I don't think many gun owners in Pennsylvania know that they're even entitled to that. Right?
No, I'm sure that doesn't sound familiar. So, I mean, as much as I hear about gun regulations, I haven't heard that. So there are protections there. Well, what kind of what kind of data? What I'm trying to get at is what is the harm when your data like this is exposed? I mean, some things are obvious, like you get my social security number, or you can steal my information, or I guess the case in the gun owners, maybe they don't want everybody to know they bought a gun. Maybe that could make them unpopular with the neighbors or their family. I don't know. But I guess that's what I'm trying to get to is what's being shared, and what are the harms that are being alleged?
Sure. So I think the harms being alleged are probably best understood when we view this through the lens of of sensitive personal information, right? So in the consolidated metapixel class action up in the Northern District that pertains to hospital systems and medical facilities utilizing metapixel on their patient portals, the harm there is I don't want my medical conditions disclosed to third parties without my consent, right? I have control over that data and that information sharing. Secondarily, I don't want targeted advertising based on the fact that I'm pregnant. I'm, of a certain diagnosis status. We always historically in privacy law talked about STDs, HIV, but nowadays it's really, it doesn't matter what the diagnosis is. The fact of the matter is it's yours to share or it's yours to protect. So I think that absolutely there is harm when this information is disclosed without our consent. It's viewed by regulators now, and it's certainly viewed by plaintiffs' bar as unauthorized disclosures. And in certain contexts, that could also be a data breach, right? That is the unauthorized disclosure of PII, and in certain instances, sensitive PII.
Yeah.
And really, Tom, I don't think we can talk about the metapixel tracking litigation and the wave that we saw basically a year ago today, filings against healthcare organizations without at least referencing Dobbs and referencing, the idea that reproductive health information in particular is viewed as just particularly sensitive. People don't want, and women don't want their reproductive health information shared, certainly not with third-party advertisers. Many that I speak to don't want it shared really outside their one-on-one relationship with their provider at all. So I think that there does have to be some recognition that Dobbs has played a role in all of this.
Yeah, absolutely. It has made, because it's such a controversial thing, it has made that information extra sensitive, as if it was anybody's business before.
Exactly. And listen, we are seeing OCR and Health and Human Services just came out last week with some new, an intention to publish a new rule regarding essentially prohibiting the sharing of information regarding reproductive health information. We're seeing states like Washington, which just passed the My Health, My Data Act, protecting personal health information, reproductive health information that did not ordinarily fit within that HIPAA context, because HIPAA, if you think about it, it's actually quite limited as a statute, right? Covered entities, business associates, providers, plans, et cetera. It doesn't really address some of these online health record companies, online prescription companies, online fertility apps, et cetera. So there is a movement at the regulatory level and at the legislative level to address this. And I think we just see that at the class action level as well.
Yeah. And I see in my most paranoid, if they're in some states making abortion illegal, I mean, not just illegal, but criminal for the woman or anyone who assists. I mean, my gosh, what happened? Well, that's a whole other subject, isn't it? I guess. Well,
I think the risk is, and I'm not the first to say this, and I think there's been OCR guidance about online identifiers, and there's certainly this new intention to publish a rule, but the risk is that you travel and your travel data your geolocation is being tracked, your travel data is being tracked, right? That there's all these data elements associated with you that demonstrate that you've violated some state law that prohibits abortion after a certain period of time. I think that the risk is real.
Yeah.
And, we're bringing this back to the idea of harm. That's kind of how we got here. I think the harm is very pronounced in that space. I think the risk of prosecution, it is crazy to me, but there are examples in some states. So these are real harms.
Yeah, they are real harms. I guess the states would argue that, well, you've done something criminal. So, you know what I mean? It's just, that's where it gets scary, because some states will make it legitimate, I suppose. You shouldn't have been doing something illegal anyway, right?
And I think at the end of the day, a lot of providers, even fertility apps, et cetera, will push back on subpoena requests and law enforcement requests from states that have those types of highly prescriptive penal laws.
Yeah. Well, I hope so. Okay. Let's see. Well, so how are companies reacting to these claims? What are the kind of defenses do they put up?
So, you got to chip away at the statute, right?
Mm-hmm.
So the majority of these lawsuits are met with motions to dismiss. And I would say about 50% of them, if not more, actually do survive. And this is just in the metapixel sort of VPPA context. Mm-hmm. That's to say nothing of chatbots and some other tracking session replay lawsuits. Again, sort of following a similar trajectory. They'll get through the motion to dismiss phase. They might be able to whittle down the claim, but these claims tend to survive, and many of them are going into discovery. There's one prominent settlement in this space by Mass General to the tune of about $18 million. And that was, again, about a year ago, I think that settlement was announced for their use of Metapixel on their patient portal. So time will tell. We're certainly tracking the trends. There are defenses, right? So when we talk about the VPPA, we're really looking at the elements. We're really looking at, do I, as a publisher, do I really constitute a videotape service provider, right? Mm-hmm. Am I really showing pre-recorded video, or am I showing live? The NFL was actually successful in narrowing a VPPA claim brought against it because it was showing live video and not pre-recorded video. So that aspect of the claim was knocked out. Other elements that I think are worth focusing on that we kind of alluded to earlier in the discussion is the idea of PII. When we're talking about PII in the consumer context, so putting aside the metapixel and the VPPA claims that we have seen in the sort of medical space, if I'm a consumer brand and I have a user ID associated with this person and this user ID views this URL, do those two data elements actually constitute PII? There's a bit of a split in the circuits between the Ninth and the Third Circuit and the First Circuit regarding what online identifiers work to be PII under this law. So there are defenses, but again, it's kind of like just slowly whittling them away through a series of motions to dismiss that we will start to get better clarity, I think, over the next 6 months, 12 months as to what the terrain is going to look like. We might also see the announcement of some settlements, certainly if they're settled at the class basis, et cetera.
Yeah. I can't help but think in these cases where, isn't it too bad people are evil and greedy? Because imagine the power of, because I remember Google was getting into the healthcare data space. I haven't researched that recently, but if you could take all this data from people and healthcare and the things you could learn from it, would be.
And there are excellent examples of how big data, and I work a lot with AI technologies, including in the healthcare space, are being used to improve healthcare decision-making. Absolutely. There are consumer, patient, et cetera, benefits from some types of data collection and analysis. But there's ways to go about that where either you're using synthetic data, you're using de-identified data, right? Like, why do you actually need some of these data elements? And when I work with businesses proactively in compliance, we always take a look at, what is your business purpose behind collecting this data element or this identifier in the first instance? Do you really need it for your use case? Oftentimes the answer is, I guess we can forgo it, right? There was like this early 2000s, mid 2000s tendency to just gobble up as much information as you could, right, thinking at some point in time it would be valuable to you. Well, now it's become a liability, especially if it's PII. Right. Especially if it's associated with a person, right? It has risks now. So we need to, as businesses, we need to data map. We need to look at our data flows. We need to justify why we're collecting the information we're collecting. And then we need to look at whether we're doing it in a way that complies with law, right? Are we getting requisite consent? Do we want to just affirmatively obtain consent, even though it might not be strictly required? There are, and I always say this because I see this particularly in the AI space, there are a lot of really incredible uses of data and technology for the betterment of, humankind,
right? Absolutely.
That sounds like an exaggeration, but it's kind of true. But we've got to do it in the right way. And we've got to kind of drill down privacy by design, right? We got to insert these ideas and these values in the product ideation phase. When we're considering a new use case, we've got to do our privacy impact assessments, et cetera.
This just occurred to me. How does it, with all this health data, because you can identify where the data came from, are there measures in place to like really mask, like it's many layers of masks over like whether I had the flu or I asked about eczema or whatever, to really use my data, but make it in no way easy at all to connect to me?
So HIPAA actually has rigorous de-identification standards. So if ever there was a statute where you could leverage and you could, look to comply with the specifics, and they're very technical statutes. So yes, I mean, de-identification exists as a concept, but it also exists under the HIPAA regime as a technical standard. This is available to organizations. So if you want to, collect the information, can you synthesize it in some way? Can you immediately de-identify it? Can you aggregate it? The idea is it cannot be capable of reversion, right? It cannot be capable of being reverse engineered back to be associated with the person. But these are fun technical questions that, your in-house data scientists or maybe outside consultants that you leverage can really provide value on.
But the incentive to de-identify in the marketing and advertising space is low because they can make so much money. I mean, generally speaking, if I knew there was a trend in consumer in what consumers were looking for, that's one thing. But if you want to know what Tom Hagee is looking for, which is what they want, then that becomes less valuable to them. So go ahead.
There is this feeling that we need to advertise to the individual, not to the audience and not to the demographic, right? So I would agree with that. I think that there is tremendous value there. That being said, we're already seeing Google has announced that it won't be allowing third-party cookies on its Chrome browser, I think, in the next year. We're seeing a move, and there's a lot of chatter about it, but we're seeing a move to this idea of a cookieless future, right? So how do we effectively market and advertise without necessarily collecting at that level of individual PII? Because I agree with you. That's the level they want to be
right.
at.
Yeah, no, I get that. I mean, some of it we're learning, just some things are just comical. I mean, I sent somebody a picture of funny pajamas that I would like to wear, and it turns out that it was the image was actually they weren't adult. It was just some ridiculous looking. And I sent it to somebody, or I posted it on Facebook or something like that. Turns out it was children's pajamas. So then all I was getting was ads for children's pajamas for a couple of months. At the same time, I was doing some research on hearing aids for a reason, not for myself, just in general, as part of my work. Now I'm getting children's pajamas and hearing aids.
The question I get more than anything, honestly, is I was talking about this topic with my friends. Yeah. My phone was near me. I pick up my phone a few hours later and I see an advertisement for, like the idea of, are they really listening in? Yeah. I mean, I hear you.
No, they are.
But if you're looking for children's pajamas and hearing aids, you're going to be serviced ads for children's pajamas and hearing aids. That's our ad tech ecosystem.
Yeah. I mean, what kind of a miss is that though? I mean, it's just not, my hearing is great. I don't wear kids' pajamas.
I'm sure you have a very unique brand, or some profile on you is very unique, Tom.
I'm sure it's bizarre, but I have seen that happen too, where you're having a conversation or a text or something, and stuff starts to pop up. Lately, Siri has been hearing us from another room. I'll be talking to my wife in another room, and then she's saying, and I hear Siri, I don't understand what that is. I'm like, well, who asked you? What?
Who? Yeah. I mean, listen, Alexa video recordings have been used in criminal trials at times where no one in the household knew that the Alexa was on and recording. Right. So the Internet of Things, we live in a highly interconnected world with all sorts of Wi-Fi connected devices that are on even when we don't think they're on.
Some of it is just so fun and so valuable Even to the point it could be amusing or it can help you humankind. But
Sure.
there's everything in between. Well, Myriah, is there anything else? Myriah, I did say that.
You sure did.
Now all I can think about is Mariah Carey. Do you, is there anything else you wanted to add? This was really helpful.
I would just mention there are ways. So after the sort of awareness about Metapixel, right, over the summer, because of an article that was published prominently, because of this large uptick in class action litigations, we've worked with a lot of business to evaluate their use of the Metapixel. Many are disabling it if they're in a regulated space like healthcare. Some are doing a privacy impact assessment or other risk assessment and determining to still implement Metapixel and other tracking technologies. The point is, you as a business owner, you as a website operator, you need to really take a look at what's going on externally on your digital assets. And what I saw more than anything in the last 8 months, 12 months, et cetera, was, legal and compliance over in this silo, and advertising, marketing, maybe some outside digital ad tech vendors over in this silo, and they're not talking to each other. This is an opportunity for cross-functional teams, for different business units to really get to know each other and talk to each other and understand what's going on. There are some really cool tools, some of which are publicly available, to allow you to kind of audit your website and really understand. You might not even know how many cookies and pixel tracking technologies are being utilized on your website. I mean, someone does, at least on the pixel tracking front, but you as a business owner might not. So we do need to start thinking really proactively in this space, because these lawsuits aren't going away. And we need to sort of take a compliance approach to mitigate our risk and put us in a legally defensible position.
Gotcha. Good summary. Myriah Jaworski, thank you very much for talking to me today. That concludes this episode of the Emerging Litigation Podcast. If you have any questions about anything you heard on the podcast or would like to participate, please write to me at editor@litigationconferences.com. The Emerging Litigation Podcast is a co-production of HB Litigation and Critical Legal Content, my companies, and Fastcase, and our friends at Law Street Media, David Nair, Editor-in-Chief. This is also the audio companion to the Journal on Emerging Issues in Litigation, published by Fastcase, Full Court Press. Tom Hagee, Editor-in-Chief. Morgan Wright, Publisher. I'm your host, Tom Hagee. That's why I'm talking, and I don't know if it needs to be said, but this is not legal advice. Unless telling you it's not legal advice is legal advice, although I'd argue it's just plain common sense. Thanks for listening. Give us a rating, share with friends. See you on the next episode.